There is a cross appeal also, my lord. So,
Interval within 2 weeks.
uh,
List accordingly
deeply.
as per usual process. Item 32.
May it please your lordship. Your lordship privileges official dated 2nd of May, your lordship. In IA 276924. Respondent 1 to 4 has appeared.
Respond number 1 to 4.
Has appeared, your lordship. And subsequent petition he had filed way back in the month of February itself, your lordship. 5th of February, he had filed the IA for substitution. It has not been listed. So the matter will be listed
We have
along
not
with the
received the
IA for
copy yet.
substitution.
We have not received the copy of the
It's
substitution.
not listed, your lordship. The fresh IA has to be filed. It was filed in the month of
Not
February.
listed.
Not listed, your lordship.
Learned counsel, Mr.
A Das for the petition.
A. Das is present for the
Applicant, your lordship.
A. Das.
Yes, sir. On behalf of Senior Counsel, Mr. NC Das.
Learned counsel, Mr. A. Das, on behalf of learned senior counsel, Mr. NC Das is present for the applicant. Learned counsel, Mr.
Wasim Haq.
Was
Wasim Haq
Wasim Haq is present
for 1 to 4.
respondent number 1 to 4.
Respondent number 5, 6, 7, 8, and 9.
Learned counsel, Mr.
Yes.
G.R. Sinha is G.R. Sinha on behalf of learned counsel, Mr.
And Bora.
N. Bora is present for the respondent number
5, 6, 7, 8, and
5, 6, 7, 8, and 9. The learned counsel for the appellant has submitted that NIA has already been filed way back in
5th of February
way
2025.
back on 5th of February 5 to 2025. But the IA for
Substitution.
substitution
The legal rights of respondent numbers 10, 12,
of legal layers of respondent number 10, 12,
13, and 14.
13, and 14 has not been listed. List this matter along with the IA. List this matter, list this appeal, list this RSA along with the appeal on 918.
RSA is not numbered, your lordship. There is a delay.
Or list this matter, list the
IA number 2769.
IA number 2769. This is IA 2769.
It's for limit combination of delay, your lordship.
Okay, list
This is
this
combination of
IA
delay.
list this
IA
IA along with IA number 2769.
This is the IS number 2769 is not
No.
listed.
Buji Babu. It's okay.
Yes, your lordship.
List this IA along with the IA number 2769 after 2 weeks.
After a week or 2 weeks, your lord. As convenient. your lordship.
After 2 weeks positively. And you'll furnish a copy of the
Lordship, notice has to go. If they appear, we'll serve a copy, your lordship. But the IA has to be listed.
it has to be listed.
Yes, your lordship.
Then only you'll get the copy.
Much obliged, your lordship.
Oblige, Your Lordship.
Lordship, the second appeal has been already admitted. Meanwhile, we could not serve notice upon the sole respondent. Why? Because his address, it was shown that he is not residing in the place. Thereafter, we tried to collect his alternate address. Ultimately, we could find his alternate address. We have filed a affidavit. So we may be allowed to take step in the new address for respondent number 1. Sole respondent.
Okay. Where, in which, you have filed an affidavit in, which one?
In the RSA.
RSA, which,
First
oh,
file.
in the RSA itself.
In the first file itself, it is there.
Okay. RSA তে লিখি দিয়া তেতিয়াহলে। Admit কৰাই আছে।
Sure.
Learned counsel, Mr.
BK Bhagavati.
BK Bhagavati is present for the appellant. গোটেইখিনি একেলগে লিখি দিবা হা। Full stop. Appellant to take steps to issue notice to respondent number
Sole respondent.
to the respondent in his new address.
Lordship.
In his new address, as per usual process, returnable within 4 weeks.
Lordship.
List accordingly. RSA to উপর দি গোটেইখিনি তলত লিখি দিবা IA বুলি। Item 35.
My lord, in this case, my lord, in the Miss IA, my lord, notice has already been served from the report. And so far is second
IA in IA.
in
IA number 200.
RSA is 200.
IA number 3324.
IA number 3324
Okay.
and another IA 3324. Kindly see the 3324, madam.
And another is 3322.
Another is 3322.
Okay, 3324.
Here, kindly see the office note, my lord.
Hmm. Okay.
Notice served.
Hmm.
And so far as second appeal is concerned, my lord,
Hmm.
in the second appeal, kindly see office note. We have taken steps on respondent number 2 and 3. But in so far respondent number 1 is concerned, my lord, we'll have to take steps
In second appeal.
in second appeal.
And India IA
I served
on respondent number 1 also.
or one also. Receive notice.
You want to press the IA?
IA,
IA is relating to what?
one IA is relating to injunction and another IA is relating to stay. So
Okay, then
regarding
you-
stay,
then you
I am
appear.
not pressing, but so far as injunction is concerned, I am pressing, my lord.
You want to press?
Yes,
Ex parte?
because they are even after receipt, they are watching that whether any order has been passed or not. If any order is passed, then they will come, my lord. So at this stage, my lord, in injunction petition, my lord, status quo with regard to the suit property be maintained. Then automatically they will come, my lord. They are from Fancy Bazaar, not far away also. Process server went there, they are served the notice. Registered post also we served the notice. Not one occasion, two occasions.
The other IA is relating to?
Stay, that stay, I'm not, at this stage, I'm not. I am only 3322. In all three cases, I have taken steps, but they are not avoiding the service. They are accepted notice, but they are not appearing. In the main case, my lord, the learned court below held that I have failed to prove my exhibit 1 cell deed. But it is the admitted in the written statement by the defendant that yes, we are the owner. We have produced the certified copy of the cell deed. And
What
even
is the land pertaining to?
pertaining to a shop house over the Fancy Bazaar area.
Which one?
Minus shop,
Shoe,
shop,
shop of
cloth.
float.
Our predecessor had purchased this suit land by way of exhibit 1, and we produced the certified copy because this original cell deed is not with me. That is with the predecessor of the present appellant, and they have also admitted that yes, we are the purchaser, and they are brothers in relation, brothers.
What are the names? Brothers' names?
That is the respondent number Imtiaz Rasul, wife of husband of respondent number 1, Imtiaz Rasul.
And the other brother?
Other brother, this is other brothers is the Iftikhar Rasul. Iftikhar Rasul's in our side, our predecessor, and their predecessor is the Imtiaz Rasul.
Yes, you can place your submission. Let's see if I can grant you ex parte or I want to hear the other side also. You can place your submission.
My lord, kindly see the plaint, my lord,
Hmm.
in the memo in the second appeal, my lord.
Hmm.
This is plain
In the
filed by,
second appeal.
yes, because it is in the main I also I have an example.
Okay.
Kindly see from the IA also, page 18,
Page 18.
18. This is basically a suit for declaration and for injunction.
Hmm.
Injunction is that, my lord, granting injunction against the defendant, restraining him from demanding rents from the tenants, minus with regard to Schedule B premises and otherwise interfering. This Schedule B premises is our purchase land
Hmm.
by way of registered sale deed that I have mentioned in this plaint also, my lord. Kindly see paragraph number 1. Paragraph number 1, that predecessor interest of the plaintiff, lordship got it,
Yes.
purchase plot of land measuring 5 and 1 and 4 lesser described in Schedule A below on payment of proper consideration from his personal income and upon execution and registration of village sale deed dated 10/1/1963 from Mujammel Hussain and obtained possessions thereof. We are claiming on the basis of this.
Hmm.
Now, what happened? Next paragraph, see kindly. This is predecessor of the plaintiff got necessary mutation in the records of right in the time. Accordingly, separate patta has been issued in his favor by the government. Patta, we have produced the patta also, my lord.
Hmm.
Though we have not produced the original sale deed, but we have produced the patta also and certified copy of the sale deed. Thereafter, late Iftikhar Rasul made RCC construction on the suit land, as described in Schedule B below, and thereafter write memorandum of agreement dated 1/1/1969, inducted one Kishore T. Mardani as a tenant from running the business under the name and style Minus at monthly rental of rupees 800 per month, payable within first week of the next month as per English calendar. That your plaintiff states that defendant happens to be the full brother of Iftikhar Rasul. Here in this case, defendant Iftikhar Rasul and the brother had very cordial relation with each other. He used to rely on him for his all purpose. The defendant also used to apparently maintain a good relation with the Iftikhar Rasul and in the process got his name included in the memorandum of agreement dated so and so. So when the suit property
Hmm.
was taken over by the Minus
Hmm.
as a tenant, in that memorandum of agreement, my brother's name was also included because there was a cordial relation. So in the process, my lord, my brother now my brother is collecting rent from Minus, though the property belongs to my
Now you want
predecessor.
to stop this collection of rent.
Yes. Otherwise,
But now the brothers have passed away. Both the brothers have passed away.
passed away. Now, brothers, the present respondent, the brothers,
They are not allowing.
they are collecting rent.
So you want to stop that.
Yes. Otherwise, if they collected rent and getting over the rent, subsequently, I will not get anything from. And even from the beginning, I am not getting anything after death of my father. At the time of my father, there was everything okay. After death, problem started.
No, not expert. I'll have to hear the other side.
But their only problem is they are not appearing. This is the problem.
One last date I must give them. I'll
My
give
lord,
them one last-
that may be reflected if on the next date they are not appear, it may be proceed expertise against them. That reflection may be there.
Yes, yes, can be. Can be reflected. Our learned counsel, Mr. S.K. Ghosh, for the applicants, IN number 3324 লিখে দিবা, হা? The to this application, the applicants have paid for stay. This is stay, I think, 3324.
3322.
Okay, you are pressing 3322.
3322.
Okay, okay, to 3324 now, 3322. 3322, huh? So this application, the applicants have filed through this application. This application is under order 39 rule 1 and 2 read with section 151 of the CPC for injunction. With prayer for injunction.
Restraining for collecting rent.
Or restraining the respondents from collecting rent from the suit property mentioned in the schedule B of the application.
Yes.
Office note dated 3/1/2005 indicates that notices have been served to respondent number 1, 2, and 3, but the respondents are not represented today. The learned counsel for the applicants have prayed for ex parte injunction as the balance of convenience is in his favor. However, a last opportunity is accorded to the respondents, failing which this matter will respondents for appearance lihidia, failing which this matter will be decided ex parte. This matter may be decided ex parte. List after 2 weeks. List after 2 weeks. And any
A date may be fixed. A date may be.
and what about the other cases? All the processes have been served.
In I number 3324, process has been served. Here also same order mail.
RSA also.
In RSA, my lord, only respondent number 1 was not served.
Okay.
2 and 3 served.
It I to a order. Do it I order.
And in RSA, I will take steps on respondent number 1.
RSA लिखा respond basically applicant to take steps to issue notice to respondent number
1.
1 returnable within 2 weeks.
And regarding 2 and 3, it may be accepted because note is there.
I will pass the order later.
Much.
Item 46.
Wait, please, Your Honor.
Yes.
Well, this is IA regarding my lord condonation of delay. In fact, my lord, what happened? The money suit was proceeded ex parte against the present appellants, my lord. And thereafter, they filed one petition before the trial court. Then, my lord, the trial court rejected that application. Therefore, there is a huge delay of 546 days. But the fact is this, my lord, they are resident of Nalbari district.
Hmm.
The suit is filed in, my lord, Kamrup district. Therefore, they have not received the notice.
Hmm.
Another thing is this, my lord. The money suit against the defendant number 1, he expired, my lord. It's a farm. That is the husband of the present appellant number 1.
What money, sir?
The original money suit, which was, my lord, decreed ex parte,
Ah,
this is against the husband who was a, my lord, proprietor of the farm, and it was a amount of rupees, my lord, 31,25,059.02. This was decreed. Then when the, my lord, they have filed the money execution, title execution case, my lord, money execution case, then they have received the notice. Then they came to know about the
but
money
this is
execution
for
case.
orders, no? This is fixed for
Yes.
orders. So
This, my
why
lord,
is it fixed for orders?
orders, my lord, we took steps upon the respondents, and I think they have appeared.
Respondent number 1, my lord, I am appearing for respondent number 1.
Hmm. What about other respondents?
There is one office
According to
note.
process, our respondent number could not serve as address left the firm. Addressee left the firm.
Yes.
Respondent number
This is
2.
the problem, my lord. But what happened? He was the manager of the firm, our firm, and he has left the firm, my lord. Now, where he is there, I don't know, my lord. But the main respondent, they are appearing, my lord. Now, what happened, my lord? The title execution case recently, they
Do you want to proceed against the respondent number 2? He was
it's
the
necessary,
manager of
but it's necessary.
necessary party.
But what happened, my lord?
Then you'll have to serve notice.
We shall try again, my lord, by justice service also, if necessary.
Yes.
Because- Yes, my lord.
And
Because
what about respondent number, other respondent?
no, only
for-
2 respondents.
For the
The main
respondent
respondent has appeared. Now, the thing is this, my lord, the trial court below, my lord, has issued a writ, my lord, against the order, my lord.
Attachment,
Yes,
writ of attachment.
yes, my lord. So therefore,
Hmm.
one, my lord, at least stay order is necessary at this
We
stage.
will file objection.
Otherwise, my
against
lord,
it.
Hmm?
otherwise what
We'll
happened?
file
Have
objection.
you
against-
filed any application for stay?
Yes, it was there, but it is not numbered because this delay condonation has only numbered. It is not yet disposed of. This is a problem, my lord.
You want to file objection?
Yes, ma'am. I have
delay-
received instructions to
Huh?
file objection.
In that limitation petition.
Yes,
Let her file objection.
My lord, in November, they have appeared in December. Till today, my lord, they have not filed. Notice was issued in November 13. My lord, title execution of my lord 31 lakhs against the,
Writ has been issued.
yes,
2
Day
weeks.
before
So you
yesterday.
will have to file within a short period of
2 weeks time.
2 weeks is long time, my lord. Then till then, my lord, at least status quo. With regard to the title execution case.
My
We have
lord,
no,
right, execution was proceeded ex parte, but notice was received in case of pre-mediation also, money suit also, and execution also, in same address, my
these
lord.
things are
Then
matter of, my lord, appeal.
Then, my lord, after delay, after the condonation delay, then only stay may be, application for the stay may be
Yes, yes,
proceeded.
yes,
So that is
yes.
also matter of record, my
Yes,
lord.
yes.
Now,
You'll have
problem
to-
is this, my lord,
okay,
if they,
the first you'll have to we'll have to dispose of this petition first. Condonation of delay. Let her file objection. And then we won't wait for respondent number 2 because he is your employee.
yes, yes,
So we won't wait for, but you take notice to justice service.
yes, my lord.
Okay. Learned
Within-
counsel Mr. R. Gusam is present for the applicant stroke appellant. Applicant stroke appellant, learned counsel Miss
P. Mishra.
P. Mishra is present for the respondent number 1. Office note dated 29/4/2025 indicates that notice could not be served on respondent number 2 as the address was not, as the addressee had left the address. Left the firm. And the notice has been returned with postal remark refused. Refused will be you.
Yes, no, refused by him. Refuse means, my lord,
No, but he has left the farm. He has left the farm. So that others will not accept notice. And you are the proprietor of the farm. Who has refused?
no, my lord, he
Very
is now not
complicated.
in our farm.
Or not your farm?
Yes, yes.
Whose farm?
It may be, my lord, the farm of the respondent. I have to, my lord,
No,
therefore,
you,
let
so you told me he was your employee, that is why.
earlier,
Earlier.
then he left. Well, let us take, my lord, fresh steps upon the,
Your present
justice.
address is Afzal Ali. Whose firm is it? Afzal Ali? Proprietary firm, namely Afzal Ali. Whose firm it is?
Of the petitioner number 1. The husbands of the petitioner number 1.
Husband of petitioner number 1. That is your firm.
No, my lord, this petitioner number 1, she is the wife of the, actually the defendant number 1. The defendant number 1 has already died. The farm also, has
Afzal
al-
Ali is your husband.
yes, he has expired.
I understand. So
The
refuse
farm is
by
no
the
longer
farm.
there. Because the sole property is
No,
farm.
no. Will not get into all this.
No, my lord, then
Addressee has left the address. Bas, baki khini kati diya.
we'll take justice service.
Where
By-
applicant stroke appellant to take steps rooted to dusty service
Upon the respondent number 2.
to serve notice on the respondent number 2 within 4 weeks, 2 weeks, within 2 weeks. Learned counsel for the respondent has submitted that that the respondents will file objection. Full stop. Prayer for time to file objection is allowed. Respondent to file objection within 2 weeks positively.
Much
List accordingly.
Obliged, my lord.
The condemnation of delay petition.
Hmm.
I am appearing for the respondent number, sole respondent, madam. Who was the defend
How many days?
448 days.
448 days.
I'd like to file an objection, madam.
Learned counsel Mr. J. Ali, no?
Yeah, how much?
J. Ahmed is present for the applicant. And learned counsel Mr. S. Das is present for how many respondents?
Respondent 1.
Respondent number 1 and has submitted for time to 77 and has submitted for time to file objection against the application. Learned counsel Mr. J. Roman is present for respondent number 7. List the matter after 2 weeks or 1 week? 2 weeks.
2 weeks, madam.
List the matter after 2 weeks.
Date may be given, madam.
Date of the you can do the
Can it be on 26?
can be
26.
26 allowed.
Highly obvious.
Item 38.
Lordship. The respondent instituted suit as plaintiff instituted suit against the predecessor of the present appellants.
You are pressing I,
Lordship.
IA number?
IA number 250, 520/25.
Okay.
In the said suit, suit was contested by predecessor of the present defendants, appellants. Suit was decreed in favor of the plaintiff respondent. Thereafter, defendants as appellant preferred ideal appeal. That was also dismissed. Subsequently preferred the second appeal that is admitted on substantial question of law. Now, during the hearing, we have filed a petition under Order 27, Order 41, Rule 27, praying for additional evidence. What we have said that we could come to know on the same day, 26/4/2027, a sale agreement was executed, soon to be executed in respect of the suit land as mentioned in the suit, which is the subject matter of the present appeal. On the same day, a sale deed, sub-bikri. Sub-bikri means on that day without permission, without anything, on the same day, it was another sale deed was executed in respect of another plot of land measuring 1 kotha 3 lesa. Whereas subject suit land was 1 kotha 8 lessa. The price for the suit land was fixed at 2,24,000. Whereas price for the sale deed, it was fixed for 40,000. This important aspect that there are, he had that, the defendant did not have saleable right at that time. Because there are 4 brothers, because our land document shows that the 4 brothers was owner of 1 bigha of land. So therefore it comes about 1 kotha 5 lessa each. So he could not have sold 2 kotha 11 lessa because he did not have saleable right. And the sale deed is doubtful. Therefore, we wanted to bring this important aspect before this honorable court by of order 41 rule 27, wherein they have objected by filing written objections. Now it is, I'll leave it to the courts whether court will like to hear the matter today or tomorrow or other day.
Let's hear.
My lord, in this case, my lord, this application for additional evidence, my lord, additional documents, just to mislead this honorable court because he has suppressed the material facts. Under which circumstances, my lord, application can be filed for additional evidence. It is clearly stated in order 41 rule 27, my lord. Kindly see, my lord, order 41 rule 27.
CPC 122.
In case he likes to hear the matter, he wants to advance his argument, I'll start it first.
Yes. Okay.
Order 41 rule 27. Production of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional evidences, whether oral or documentary, in the appellate court, but if the court from whose decree or appeal is preferred has refused to admit the evidence which was ought to have been admitted. This is not our ground. Second, the party seeks to produce the additional evidence establishes that the notwithstanding exercise of due diligence, such evidence was not within his knowledge and he could not, after the exercise of due diligence, be produced by him at that time when the decree appeal was against passed. This is our ground. Now here is the case. AA, order 41, rule 27, AA. We have a ruling, we have a apex court judgment to show.
Yes.
We have a judgment to show. Here is that document. They admitted this document was executed. And now we have brought this document, this knowledge, this was not within our knowledge. So therefore the document is there. Rightly or wrongly, that document is there. But therefore it doesn't need any evidence to be shown. Even if this court allows this our petition, this document will come into the court. The second subsequent questions will arise. So therefore, in second appeal, it will be difficult for this honorable court to
Yes.
hear the matter on the point of evidence because it needs evidence.
Yes,
But
definitely.
when the document is an admitted that rightly or wrongly document was executed, whether that person had the capacity to execute these two documents, one agreement as well as one sale deed on that the same day, and that there was no whisper either because when she was having she wanted to buy a sale deed, buy a plot of land, say out of the same suit land, so that number. She got an execution of a sale deed in respect of the same land, part of the suit land, part of the within the suit land. Why second agreement was? Therefore, we created doubt. Yes, if it is the question of sale, what is that called? Specific performance of contract, that is a subject matter of this present appeal. Subject matter of the present appeal. But how about the sale deed? There was no whisper made in the document. Now they have raised and they have filed an objection that stating that one of the witnesses, with the attesting witness, was the son of the present applicant, son of the present predecessor of the applicant, Bijoy Das. His name is shown. But from counting the year, on that day, it is shown that on the two documents were executed, one what is it called? Sale agreement, one sale deed. In both the cases, two different sets of witnesses were there, creating doubt. Secondly, the then defendant was an ordinary person. He was a vegetable seller. He did not know the intricacies. And thirdly, why the price of the sale deed was only shown for 1 quarter 3 lakhs, only shown 40,000? Why this price for the sale agreement was shown as 2,24,000? So there was no sale permission shown to be given in that said sale deed. So there are many things to be seen. Therefore, this document, what we wanted to by way of order 27, order 41, rule 27, we bring it to life, bring it to before this, bring before this honorable court. Is already a document, which is they have admitted. She has admitted that yes, you have purchased. Now we say that this purchase was not valid. Either this or sale agreement, not both. If we agree to one sale agreement, we will like to. She has to abandon this document. That is why
Which document?
the sale deed, because on the same day.
Either sale agreement or sale deed.
Either of one, not both. Yes, because I did not have sellable right on that day. For entire 2 quarter 11 lassa. I had only right to sell 1 quarter 5 lassa. Because I had some other brothers. My brothers were not in the party. Therefore,
But
it
the
is.
suit was not partitioned. That
In
land
the,
was not
my
par-
brothers were not made party in the suit.
No, land was not partitioned.
Land was not partitioned. Because we have the land document, we gave the land document to sold. There no whisper was made on the land documents. Only because that is why when the document we like to introduce by way of order 41 rule 27, that is already they have agreed. She has agreed. Therefore, no evidence is required before this honorable court. There is no bar. So this document, by this judgment, I can produce before this honorable court so that the court can look into this matter while hearing this appeal.
Yes.
So therefore, my submission at this stage, and they have only stated that one of the witnesses, son of the original defendant, Vijay Das, was a witness, attesting witness to the sale deed. Yes, his name is Sun. But counting his years is at that relevant time he was a minor. One. Secondly, when he was made a witness to the sale deed, why he was not made witness to the sale agreement? It creates doubts. Thirdly, why the sale consideration was, or there is a vast difference between the sale considerations in both the documents. Fourthly, no sale permission or no any permission was there. It was a sub-victory. That means sub-victory. So therefore, it creates doubts whether the defendant, whether the plaintiff came before this honorable court with clean hands or not. So, and accordingly, this already, we have the document to show, we have this present appeal has been already admitted by this honorable court. And there are enough rulings to show that their sale deed, their suit was time barred. We took the plea. Time barred, we will prove it that it was time barred because from the first date of cause of actions. So therefore, I humbly pray before this honorable court to allow this petition so that these documents come before this honorable court
Okay.
at the time of hearing.
May I please, Lord?
Yes.
My
Give
lord-
me the ruling.
I'll give.
And the
I'll
relevant
give.
paragraph. Yes.
My lord, originally suit was title suit number 57/2007, 2010, my lord. Regarding specific performance of contract and agreement. Because the appellant herein as a defendant in the original suit was entered into an agreement for sale with some conditions. If break the condition, then the land will be registered in favor of the plaintiff. Ultimately, they break the terms and condition, and the plaintiff has filed for specific performance of contract. That suit was decreed by the learned Munsif, and thereafter, first appeal was preferred before the additional session district judge, and it was also upheld and decreed in favor of the plaintiff.
Case number.
So there is a concurrent findings, my lord, regarding the suit. And against that appellate order, my lord, they have preferred the second deal. Now, the agreement, my lord, kindly see if it is, I can show, then my lord, it will be clear. Otherwise, sale deed and agreement, there my learned friend's admission is, submission is that both the same. Actually, sale deed is different, agreement for sale is different. It is with two different lands. With two different lands. One belongs to his brother, the appellant was purchased from his elder brother by a sale deed, and that is a separate land. And another agreement is agreement for sale, it is his own land entered into to sell to the plaintiff.
Own land of plaintiff.
Own land of the plaintiff, not defendant, original defendant. Original defendant. And the original defendant has a purchased the another plot of his elder brother, that is against which he made the sale deed. That was sold first. There is a two, one sale deed, this is different land, and the agreement for sale is different land. Agreement for sale is the defendant's own land, own share of land, and the sale which is sold to the plaintiff. This is an land which the defendant number one purchased from his elder brother. It is very much clear from the sale deed itself, annexed by the learned friend in IA number 520/2025. My lord, kindly see the
Which one? Page? 520 of 2005, 25 page?
page 18, my lord.
Okay.
This is the sale deed, my lord. And the Madhavi Muzumdar was the plaintiff. And Pankaj Kumar Das, Pankaj Chandra Das is the defendant.
Okay.
He is the seller. My lord, kindly see the third paragraph.
What paragraph? Yes.
Third paragraph, my lord. পোষ্য মাটি বিক্রি সাফকাওলা খতপত্র মিদং কার্যগ্রানে যেহেতু মোর টকার বিশেষ প্রয়োজন হওয়াত মোর নামত যোৱা ইংৰাজী 23/2/2089 1989 তাৰিখত হোজাই উপ পঞ্জীয়ন কাৰ্যালয়ত পঞ্জীয়নভুক্ত 354 নম্বৰ সাফকাওলা দলিল মূলে খৰিদা হক সত্য, that means Pankaj Chandra Das, he has purchased this plot of land from by deed number 554. He has purchased this land and this land has been sold. হক সত্য মোর নিজ ভোগ দখলত থকা আনক বিক্ৰী বন্ধক ও কোনো ধৰণৰ দায়বদ্ধ নকৰা নিম্ন তপশিল বৰ্ণিত দাগৰ পৰা মোট 1 কোঠা 3 লেচা মাটি আজি নগদ মোট 40,000 টকাত সাপ বিক্রি করে দি মাটির দখল ভোগ আজি বরাবরক সমঝাই দিল।
So this is condonation of delay only?
No,
Condonation of delay does not arise here, my lord.
Stay, this is stay for what? Oh, so.
this is order for your
For
condition
additional evidence.
evidence.
Additional limit.
Additional evidence.
Then, my lord, can you see the next page? উক্ত মাটিত মোৰ যি হক শর্ত বা লাভালাভ আছিল আজিৰ পৰা সকলো ৰহিত হৈ মোৰ স্থলত বৰাবৰৰ শর্ত ও দখল বৰ্তিল। উক্ত বরাবৰৰ এই দলিল বলে মোৰ শর্তে শর্তবান মালিক দখলকার থাকি মোৰ আখ্যাততে বা অসাক্ষাতে নিজ নামত নামজারি কৰাই লৈ পুত্ৰ পত্ৰাদি ৱাৰিছগণ ক্ৰমে ভোগ দখল দান বিক্ৰী আদি কোনো প্ৰকাৰৰ হস্তান্তৰ যিকোনো প্ৰকাৰৰ হস্তান্তৰ কৰিব পাৰিব। তাত মোৰ কোনো ওজৰ আপত্তি দাবী দাবা নাই ও নকৰো
Okay.
বা মোৰ
okay,
আন
it's okay,
কোনোবাই
it's okay.
ৱাৰিছগণে
It's okay.
কান্দিছি লাস্ট এতদিতে স্বইচ্ছায় সজ্ঞানে নিজ হাতে নগদ টাকা সমঝি পাই মাটি বিক্রি সাপতলা খতপত্র দিল
Sale deed, yes, sale deed,
sale deed that is executed on 5/4/2007
registered sale deed.
Sale
Yes.
deed.
Yes, sale deed, yes.
sale deed. So this is the land, my lord. The defendant number one, appellant herein, original appellant herein sold to Madhavi Muzumdar, plaintiff. Now, my lord, kindly see. And after this, my lord, passage.
Madhavi Muzumdar sold this land.
No,
No, Madhavi Muzumdar was the passenger.
Madhavi
Passenger.
Muzumdar purchased this land from,
Pankaj Chandra Das.
he is the defendant.
He is the defendant number one.
And now
He is the
here,
defendant.
now here he
Sole
is the,
defendant
He
in the
died.
title.
he died, therefore,
Ah.
during pendency of second appeal, he died.
Ah.
The present appellants be his legal heirs, including his wife,
Up to
Putul Das.
Putul Das and his daughter, her
Okay,
daughter,
okay, okay.
sons and daughters.
Okay. So he is the plaintiff.
Madhavi Muzumdar was the plaintiff,
Ah.
she is the plaintiff,
Ah.
and Putul Das and other now present appellants and defendants,
You are the defendant, original.
the original defendants.
original defendant. My lord, kindly see the witnesses, last witnesses. Tikendra Saha, 1 number. Number 2, Bijoy Das. This Bijoy Das is the son of this Pankaj Chandra Das. And he is the applicant number 2 in the IA.
Hmm. Yes.
Now, my lord, and after purchasing this land, my lord, Madhavi Muzumdar has mutated his name, separate patta was issued, so far this land is concerned. 1 kata 3 lasses is concerned. Now, dispute between the parties is the agreement for sale. That is, my lord, on the record, kindly see that is the agreement for sale. This is land measuring 1 kata 8 lasses. Between the same parties, Madhavi Muzumdar and Pankaj Chandra Das.
But different land,
But
different plot of land.
they were
No.
that his land, his own land.
No,
That was
it
the
is same
land.
tag number, same patta
Please,
number.
please sit down.
I'll see
The
the-
earlier sale deed, Pankaj Kumar Das has purchased 1 kata 3 lasses of land from his elder brother by deed number 354,
Hmm.
dated
Yes,
23/2/1989.
purchase, and the dispute is agreement for sale.
This is separate land.
This is not disputed.
This is not disputed. Already mutated, already she is in possession, the plaintiff is in possession. No dispute, right? Up to 2007 to 2024, no dispute. Now suddenly he has come forward to produce the document as if the agreement for sale, this land and the land of sale deed is the same. Their contention is this, because they were executed, registered on the same day. Though sale deed was executed on another date, but registered on the same date, but executed on another date. This is separate land. It is the mutual understanding between the purchaser and the seller. So this is not disputed. This land is not disputed at all. And up to the title suit to second appeal, the appellant, that is original defendant, did not raise any question regarding this sale deed, nor he has produced this sale deed as a defense in the title suit, in the first appeal, even in the second appeal during his lifetime. During his lifetime, that is Pankaj Chandra Das. After his death, my lord,
Hmm.
suddenly his legal heirs were brought on record, and now they wanted to make out a new case that this sale deed is related to the present second appeal, and they wanted to produce these documents as an additional document.
Okay.
So this is not at all. Kindly see the agreement for sale. It is exhibit 1 in the,
So they appeal as it is admitted.
Yes, Lordship, that is my
Yes.
submission. Let the document be there. It will be at the time of hearing of the main appeal, it will come.
no, my lord, my humble submission, my lord, this is separate. Separate means case it should be
Let him
disclosed
finish it
first.
up, I will prove it, it is not separate.
Otherwise it will create another problem because
That's what.
because second appeal was hard for, kindly see the record, my lord.
Mm.
I am not submitting from it. Kindly see the record. How many days has taken for hearing
Yes,
of the
yes.
second appeal? In the midst of the hearing, this question has been raised.
Mm.
Already substantial question has been raised, framed. Matter was heard, matter was fixed for hearing for few days,
Mm.
one after another.
Yes, yes.
And subsequently, my lord, this petition has been filed. So it is nothing but a dilatory tactics, nothing else.
Lordship, if he has finished, I'd like to.
No, I from not replace it.
I will reply.
Kindly see, my lord, their agreement, the present agreement, which is the disputed land with the disputed land.
Mm. Page, where, in the.
My lord,
RS?
exhibit 1 in the original second appeal, my lord, it is the records is there, my lord. Exhibit 1.
But this is not in the RSA, copies or anything.
In the IA, it is not annexed, my lord.
RSA?
RSA not in the record, my lord.
It's a C file, it will be there, the trial court file.
My God.
Title of part, exhibit 1.
Yeah, will you have to see file, exhibit 1. It will be in the trial court record,
Lordship.
Yes.
see file, trial court record. will be. এরও কোন দেখিয়েছে ঠান্ডা তো অকমান দেৰি কাৰণে I think it will take time.
Sometime it is necessary, my lord.
Your
That is
other
why.
matters will be left over. Will all the matters will be left over. And then item 17, you want a date left over. Okay.
Step number लिखियो लगे.
I think it will be left over because this won't end very soon. It will, I think it will stretch even beyond 4:30. Looks like. Because this is the main point in the second appeal. It will have to be disposed of. So matter should be left over. Therefore, record C5. Exhibit number?
Exhibit 1.
Exhibit 1. এইটো হেৰি ইফালে নাথাকিব এইটো হেৰি বি ফাইলত থাকিব নেকি C2 ফাইলত নহব
Exhibit 1 is the agreement.
C1 file.
Exhibit 1 নাই এইটো নহয়। এইটো নহয়। এইটো Exhibit 5 ইয়াতে অলপ Exhibit 2 Agreement হয় Agreement. Exhibit 1 এইটো নহয় Agreement হ'ব Agreement টো এনেকুৱা নহয় এইটো বন্ধ আছে নেকি? Yes, I got it. Yes.
Yes.
Exhibit 1, yes.
My lord, kindly say, my lord. প্রথম পক্ষ শ্রীমতী মাধবী মজুমদার, স্বামী হরি মজুমদার, জাতি হিন্দু, সোয়েঞ্চ। সেকেন্ড মাই লর্ড, দ্বিতীয় পক্ষ শ্রী পঙ্কজ চন্দ্র দাস, পিতা সোয়েঞ্চ। কশ্য বাটি বিক্রি বায়না নামা খতপত্র মিদং কার্যজ্ঞানে মাটি বিক্রি মাই লর্ড কাইন্ডলি সি কৈশ্য মাটি বিক্রি বায়নানামা খতপত্র মিদং কার্যগ্রামে যেহেতু মোর পক্ষ হকৰ সত্তৰ দখলীয় দিনম তপশিল বৰ্ণিত মুঠ 1 কঠা 8 লেচা মাটি প্ৰথম পক্ষৰ ওচৰত চৰ্ত সাপেক্ষে বিক্ৰী কৰিম বুলি প্ৰকাশ কৰাত আৰু প্ৰথম পক্ষই উক্ত চুক্তিত আগ্ৰহী হোৱাত মই মাটিৰ মূল্য 2,24,000 টকা বন্দোবস্ত ক্ৰমে আজি বায়না বাবদ নগদ 95,000 টকা প্ৰথম পক্ষৰ পৰা দ্বিতীয় পক্ষই সঞ্জি পাই স্বীকাৰ কৰিছে যে দ্বিতীয় পক্ষই উক্ত প্ৰথম পক্ষৰ বায়নাকৃত টকা চলিত বাংলা চনৰ আশ্বিন মাহৰ 30 তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষৰ ঘূৰাই দিলে প্ৰথম পক্ষই কোনো ওজৰ আপত্তি নকৰাকৈ উক্ত বায়না টকা ঘূৰাই ল'ব ও ল'বলৈ বাধ্য থাকিল আৰু তেওঁৰ আৰু উক্ত আহিন মাহৰ 30 তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষই প্ৰথম পক্ষৰ বায়নাকৃত টকা ঘূৰাব নোৱাৰিলে চলিত বাংলা মাহৰ পুহ মাহৰ 30 তাৰিখৰ ভিতৰত বাকী টকা সমুদায় 1,29,000 টকা প্ৰথম পক্ষই দ্বিতীয় পক্ষক আদায় দি দ্বিতীয় পক্ষই কোনো ওজৰ আপত্তি নকৰাকৈ প্ৰথম পক্ষৰ নামত মাটি বিক্ৰী চাপকাওলা হোজাই উপ পঞ্জীয়ন কাৰ্যালয়ত গৈ ৰেজিষ্ট্ৰি সম্পাদন কৰি দিবলৈ বাধ্য থাকিম দ্বিতীয় পক্ষই অৱশিষ্ট টকা নলৈ তাল বাহানা কৰিলে বা প্ৰথম পক্ষই ম্যাদৰ ভিতৰত বায়নাকৃত টকা গ্ৰহণ নকৰি তাল বাহানা কৰিলে প্ৰথম পক্ষই বা দ্বিতীয় পক্ষৰ টকা আদালতত জমা দি অপৰ পক্ষৰ পৰা মুক্ত হ'ব দ্বিতীয় পক্ষই ম্যাদ অন্ত হ'লে প্ৰথম পক্ষৰ পৰা অৱশিষ্ট টকা নলৈ অসুবিধাৰ কৰিলে প্ৰথম পক্ষই আইনৰ আশ্ৰয় লৈ মুঠ মাটি পাব লগা হ'লে প্ৰথম পক্ষৰ ক্ষতিপূৰণ দ্বিতীয় পক্ষই বহন কৰিব লাগিব তাত আমাৰ উভয় পক্ষৰ কোনো ওজৰ আপত্তি নাই নকৰোঁ বা আমাৰ ৱাৰিছে কোনো প্ৰকাৰ ওজৰ আপত্তি দাবী দাবা কৰিব কৰিলে মিছা ও অগ্ৰাহ্য হ'ব এতদৰ্থে সেই স্বইচ্ছায় সজ্ঞানে স্থিৰ বুদ্ধিত দ্বিতীয় পক্ষই প্ৰথম পক্ষৰ পৰা কৃত টকা নগদ সঞ্জয় পাই মাটি বিক্ৰী বায়নানামা খতপত্ৰখন লিখি দিলোঁ তপশিল জিলাৰ এইটো লাষ্ট লাইন আছে যে প্ৰথম নগাঁও জিলাৰ মৌজা থানা লংকা উপ নিৰ্বাচন কাৰ্যালয় হোজাই লংকা টাউনৰ কিছামতৰ 724 নম্বৰ ম্যাদী পট্টাৰ 1540 নম্বৰ দাগৰ 1 কটা 8 লেচা মাটি মাত্ৰ উত্তৰে অমুক দক্ষিণে অমুক শ্ৰীমতী মজুমদাৰ ইন দ্য লাষ্ট লাইন এই মাটি মাত্ৰ প্ৰকাশ থাকে যে দখলবতে পৰিমাণ কম বেছি হ'লে টকাৰ পৰিমাণ কম বেছি হ'ব মাটিৰ পৰিমাণ কম বেছি হ'লে টকাৰ পৰিমাণ কম বেছি
Yes, yes.
so if the land is
Yes, yes.
more or less amount will be
Yes, yes.
changed this is the agreement accordingly the defendant has violated the terms and conditions because he could not return the money within the time frame in the agreement. So the plaintiff filed title suit for specific performance of contract.
Okay.
And that decree was passed in favor of the plaintiff. In favor of the plaintiff means Srimati Madhavi Mujumdar. Order is there. And this is the land in dispute in the original title suit. This is the land.
This is not the same land,
Madam.
not the same land.
No, this is his own land. Own land, earlier also owned land, but that land was purchased from his brother. And it is the inherited land from his father. Agreement for sale, this land is inherited from his father. And the sale deed already sold, that was inherited by his elder brother from his father. And the Pankaj Chandra Das, he has purchased that land from his elder brother. So he also is the absolute owner of that land. He sold it, but that land is not connected with this. This is a separate land. That is measuring
That
land
sale deed land he purchased from his brother.
from his brother. I have stated in my objection.
And this agreement land he purchased,
He is inherited from his father.
but same DAG number and pata number.
So DAG number, pata number same.
Only plot is different.
Plot is different. Plot is different. And they have, four brothers, they have mutually partitioned their land. And they have occupied their own possession with respect to their shares. There is no dispute among them.
Only that legal heirs have dispute.
Only now legal heirs of Pankaj Kumar Das now disputed this. That is also from 2010 to 2024.
So that evidence is not required here.
That is not different. That land is no way connected with this. This is separate land, already gone, sold, mutated, already gone. Now they wanted
So
to
I'll ask
confuse.
only one question. I'll ask only one question, not much. I also have a doubt.